In today's episode, we are wrapping up our 3-part series on how to create your wealth protection plan. If you've missed the past 2 episodes, I'd recommend you go back to episode 51 and start there. Following on from last week's episode where we covered a brief overview of wills and estate planning, today I am joined by estate planning specialist Tara Lucke, and we discuss everything you need to know about estate planning, as well as a number of horror stories of what can go wrong when you don't have an appropriate estate plan in place. Hope you enjoyed the episode.
Welcome to More Than Money with your host, Ross Marais. This episode of More Than Money is brought to you by More Time Financial, a financial planning company who are on a mission to help young Australians make smarter decisions with money by providing real-life financial advice, coaching, and financial education.
Hey, what's up? It's Ross Marais. Welcome back to another episode of More Than Money. On this podcast, I have real conversations about lifestyle, money, and business. Sometimes I share interviews with business owners and entrepreneurs about starting their own business and their journey. Other times we do financial education and informational episodes to help you make smarter decisions with money, just like this one. So if you're new here, consider subscribing. Now, before we get started on today's episode, this is just a friendly reminder in order to keep our lawyers happy that in preparing this podcast, myself and any contributors have not taken into account any particular person's objectives, financial situation, or needs. So before acting on any of this information, you should consider its relevance to your personal circumstances, and if required, seek the assistance of a licensed professional. If you wanted to start things off with maybe a horror story or some kind of worst case scenario that you've seen when estate planning has gone wrong.
Absolutely. So I specialise in estate planning and I see it all the time, how bad it can be if you don't have proper estate planning. So I guess my sort of message for your listeners is estate planning doesn't have to be hard. And for a lot of people, we can basically get a set and forget structure in place so that you've got that peace of mind. One thing a lot of people don't know is that even if you don't have a will, you do have an estate plan. So the government gives everybody a default estate plan, which sounds pretty good in theory, except most of the time it doesn't actually achieve what people want. So it's a really good idea to actually do some proper planning and get your estate plan sorted the way that you want so that your wealth passes to your loved one or purposes that you care a lot about. In terms of war stories, I think that they come up a lot for young people because there's a bit of a misconception with younger people, and I'm sort of, even people in my age demographic in their 30s and 40s, because I think a lot of people think, it's like an old person thing to get your estate plan. So a lot of young people just don't bother with it. And that's unfortunately where we see a lot of the war stories and worst case scenarios arise because they just think it doesn't apply to them. Most people, even if they don't feel like they have a lot of equity or assets, now they're in that accumulation phase. If they pass away, they will have assets because of the super, the life insurance that usually comes automatically with super. So I've seen a lot of war stories, even if you've got like a single person in their 20s or 30s, no dependents, if they pass away and they haven't addressed their superannuation nomination, it can be a real mess about where their money goes, and that can be a couple of $100,000. So there's been a few cases recently where a young person has passed away, they haven't nominated what to do with their super, and the parents are separated or divorced, and what ends up happening is there's an absolute mess between the parents about who's getting what money, and while the intention might be that the super goes equally between the parents, it doesn't work that way. And there's been instances where one parent has just taken all the super money because they can legally do that if you don't get your nomination sorted. And then what actually happens is they end up in court and then they're fighting over it. And you know who gets the super money? Neither parent. It goes to the lawyers who are litigating in fees. So what an absolute waste of money. And I'm sure that would not be where the young fellow in that case wanted his money to go. He never wanted to go to lawyers.
Well, I think that's a really good example because, as you said, young, no dependents, not much money, or he didn't get much money. Like that's a perfect example of someone saying, I don't need a will. All that kind of stacks up. Where in that case, you're saying, like, it will go nowhere. Like, no one gets it, no one wins.
So it's an absolute shame. And like, how long does it take to do a super nominee? Like 10 minutes?
If that.
2 minutes
exactly.
and a bit of a chat with you.
So I think if we took a step back from that, what is estate planning? Because when I speak to, especially a lot of young people, I'm not sure where their mind goes, but it's definitely, there's a lot of myths. There's, as you said, I didn't need when I'm old. They don't even know what estate planning is. So what is estate planning?
Okay, there's a couple of aspects to estate planning. So there's obviously dealing with the event of when you pass away, and that's when people are looking at their will, or if they don't have a will, there's the intestacy rules, which the government says this is where your money goes, and we can touch on those later. Also your super nominations. So those documents are needed dealing with estate planning for death, but there's also estate planning for while you're still alive, but if you've lost capacity to look after yourself. So nominating people to manage your finances, make sure there's enough money there, that any insurances that you have used in the right way to make sure there's enough money to care for you, and then also making sure that the right people can actually make your medical and lifestyle decisions for you as well if you can't look after yourself.
And that's in the form of obviously enduring power of attorney.
Yes, exactly right.
So we've got a will, which is obviously when you die, then that sets out where your money will go. And then you've got an enduring power of attorney, which will set out who is going to make those decisions if you can't make it for yourself.
Exactly right. And again, for a lot of young people, they really should have the power of attorney in place, because what happens if you don't is your family members have to apply in Queensland to the Civil Appeals Tribunal, and whoever's just willing to stick their hand up to the job usually gets it. And that may not actually align with who you feel is going to be best to make those decisions, particularly some of those medical decisions. It's a really value-based process. So I think for a lot of people it's critical to have certainty around the right people making those decisions for you.
And have you been on the other side of that, where you've had to deal with cases where obviously someone gets appointed that shouldn't have been appointed, and then have to try and get out of that?
Absolutely. You really can't. Once the Appeals Tribunal nominates somebody, if you haven't done a proper power of attorney, there's not a lot you can do, and it causes huge amounts of tension in the family, because they'll all have a different idea about what is the right thing and who's best to make those decisions. And unfortunately, if you didn't set those out while you had full capacity, everyone is left with a different point of view, and they can't ever go back to saying, well, we know this is what you would have wanted. It's always he says, she says, and it just causes so much unnecessary tension in an already really difficult time.
I think the way we try and explain it to people is, so there's going to be the emotional pain if there's death. Obviously that's just a non-negotiable. We can't help with that. There's going to be the emotional pain, but we can help with the financial pain. So we can make sure that the documents are in place, the life insurance is in place, make sure all those boxes are ticked. So that's just one less thing that your family has to deal with if you pass away.
It is already a difficult time, so why complicate it with difficult legal processes? Like, everything is so much harder for your family and friends to sort out if you didn't plan it properly, and adding extra tension when emotions are already high. It's like getting your estate planning sorted is not a difficult process. It's pretty straightforward. And for a lot of people, you can just get it done, basically set and forget. I suggest that you do sort of look at it for 5 minutes every year just to check in. But unless there's major life events changing, you don't have to keep revisiting it. Just get it sorted.
And you'd probably know the stats more than me, but there's obviously something ridiculous how many people don't have a will in Australia. Why do you think that is? Like, what stops people from doing it? Why is it the last thing on people's list?
I think people think it's harder than it is. And look, no one wants to think about it, even though, what do they say? There's like 2 certainties in life, death and taxes. So it is relevant for every single person, but I think no one wants to think about their mortality, and there can be a bit of stigma about if you actually sit down and address it, then maybe you're inviting death and trouble into your life. But I actually find it's the opposite with Parkinson's law. It's the people who And maybe the same with insurance. You know, the people who actually get their insurances and their estate plans sorted, you know, they never have to rely on them, or, you know, at least not for a really, really long time. And it's the people who didn't bother prioritising it that need to rely on it, and then it's too late. So look, and I think also someone said to me the other day, oh my God, just sitting with like in a stuffy old room with like a grey-haired lawyer who, you know, it's so boring, and it doesn't have to be like that with estate planning.
Yeah.
You know, these days getting your wills done is a lot quicker of a process, and I think with my clients, once we go through it, actually just get that peace of mind. You don't have to, every time you think about it, you know, cringe. It's sorted.
So on that, with the clients that you work with, is there a certain time when people should get a will and get their estate planning sorted, where it's just a non-negotiable?
Look, definitely if you get married or have children. So I have this thing that whenever my friends have a child, I give them a will with a testamentary trust in it.
Yeah.
And look, I'm not always the most popular at the baby shower, turning up with my will, but I just absolutely think it's so important. So look, everyone should have a will, but especially if you have, and especially needing a will with a testamentary trust in it.
Okay. So if you try and explain that in layman's terms, just run us through what that is, a testamentary trust.
So if we just like come up with a sample client scenario, a young husband and wife, and they've got like a child who's 2 years old, something like that. So if our wife passes away, rather than her leaving the assets to her husband in his own name, what happens is the assets go into a bit of a bucket called a testamentary trust for the husband who survived and their child. And it still looks and feels like their money. They've got total control over it, but it's technically held in a separate structure called a trust. Why bother with this extra trust? 2 reasons: asset protection and tax. So if I go into the asset protection, there's a couple of areas to that. So if we look at the statistics, who have lost their wives are like really likely to re-partner. It's something like an 80% re-partner rate, and particularly the older you get, I think the higher it is. But anyway, I don't know. I won't comment on why that is.
Sure.
But it's really common, especially with younger people, that they might re-partner in the future. If the inheritance goes into that testamentary trust, and there are new relationships with the surviving spouse, the inheritance is segregated and protected away from any issues with that new relationship. So if there is like a divorce or relationship breakdown, then the inheritance from the first relationship is kept away from that. So that can be really valuable to make sure basically that the children are protected, that money is going to ultimately be there for the children if you pass away. So you know by using the trust that your kids will ultimately get that money when they come of age. The other sort of asset protection point of it is if both of our young couple have passed away, leaving their minor 2-year-old, the testamentary trust is great from protecting children from their own financial immaturity. So obviously children who are under 18 don't get control over their money. If you don't use this trust, then the children get their money when they turn 21.
That's default.
That's a default position without a trust.
Okay.
If you use the trust, then the children don't get their money when they turn 21. You get to nominate people that you trust, like it might be your parents or close family members or friends, and they get to decide when the children are financially mature enough to control the money. So when I'm saying that the kids get their money or don't get it, they will of course benefit the whole way through. Their school fees, their living expenses are all paid for, but the kids don't get to make financial decisions about the money. So I think most people will have come across instances where there's an inheritance, 21-year-old gets control over that amount and they just blow it and they live, to regret it years down the track. So the testamentary trust prevents that from happening. You get to put people that you trust in charge of deciding when the children get financial control. And so basically protecting them from their financial immaturity.
Definitely. I've seen a few cases of that where unfortunately the father passed away, and exactly that. The son was, I think, 19 or 20, inherited a couple $100,000, and after a couple of months it was not there anymore.
Oh, and it's terrible, because if that money is protected and invested appropriately, it can just be a game changer and set them up for life versus, just blowing it all. So testamentary trusts are really good for that. For people who are in business, they're also excellent. If you have got some bankruptcy exposure, and look, when I say bankruptcy exposure, anyone who is a director of a trading business or a listed company or a sole trader has a bit of bankruptcy exposure compared to the person on the street. So it doesn't mean that you're going to become bankrupt. Most people don't. But if you have the inheritance separate in that testamentary trust bucket, then it's just not even up for grabs if bankruptcy happens. So you're keeping the inheritance protected from those types of risks. So asset protection is one of the main for using testamentary trusts. Tax is the other. So I won't bore everybody by going into the exact tax details, but basically the income that is earned on investing the inheritance can be tax-free to minor children.
Okay.
So if we go back to our scenario of husband and wife, and the wife passes away and leaves her husband and the 2-year-old, without the trust, she leaves her husband, what's a good amount of life insurance? 700,000 super and life insurance.
Yep.
Maybe that's a bit high for what most people have. But if, say, he's got that money and he invests it, there's a bit of an income, that would all be taxed at his marginal rate. So if he's also working to support the family, and then he's got this extra income, taxed at his marginal rate, it might even push him up a tax bracket, and then he's got to pay tax and then use the after-tax money to pay for the schooling and education and everything like that. If they have a testamentary trust, they invest that inheritance, they can allocate tax-free amounts to the child. So basically using pre-tax income to pay for the schooling, living expenses, it's about $20,000 per year per child, and then just your normal tax rates from there. So people with testamentary trusts, if they do have an instance where their spouse passes away, they're using pre-tax money to pay for the schooling expenses, and that's year on year.
Yeah, definitely.
And then it's generation on generation. So when that 2-year-old becomes an adult and then has children of their own, they get it again.
Oh, right. I didn't know that.
So these are the types of structures where wealthy people use them, and that's how they stay wealthy, because they're paying so much less tax than anybody else. Traditionally, they have just been the domain of wealthy people because getting this type of strategy advice hasn't been accessible. But these days, I feel like everybody should have them. They're not expensive to implement. You don't have to worry about managing or the compliance of these trusts until somebody dies. So it's not a headache, or it's not even a headache anyway, but you don't even have to worry about it unless somebody dies. But if the worst happens, then you're utilising the structures that are there to give yourself a head start.
So you mentioned small business owners or business owners being at risk. What are your recommendations for any business owners, anyone that has a public company or private company, partnership, sole trader, whatever it is? What's your recommendation in terms of estate planning?
So business owners really should be getting their estate planning done for a couple of reasons, especially if they're working on setting their asset protection structure up appropriately while they're alive. So if you are working on, we'll put the house in the low-risk spouse name, the person who's not carrying on the business. We might use a family trust to run the business or a company. You don't want somebody to die and then upset and unwind all of that asset protection. So if you've deliberately put the house in your low-risk spouse name and then they pass away and they leave everything to you in your own name, which is what would happen if you didn't have a will or you only had a really basic will, then all of a sudden you're loaded up with assets in a high-risk bankruptcy occupation, and you've either got to wear that risk and it undermines all the good work you've done, or you've got to spend money, tax and stamp duty and legal fees to transfer them out again. I'm not trying to say that it's actually harder for business people to get their estate planning done. It's not. It's just more important. And if you get your estate plan sorted, then you can make sure those assets pass in the right environment to keep your asset protection strategies going without undermining all the good work that you've done.
I think that's a really good point, because you speak to business owners and say, well, you're working so hard, you're growing this business, you've got a large amount of money, you've set it up right, you've got a company, as you said, maybe transfer the house into the other partner's name. And then you say, well, what happens if one of your own business partner passes away? Or what happens if the worst happens to this person? And they go, oh shit, I didn't think of that. And as you said, all their hard work, everything they've built up can just get lost, basically, or lose to tax and legal fees.
And like estate planning is really just about having your hard-earned wealth go to the right people at the right time. And what we mean by the right people is your loved ones, your friends, your families, or charities that are important to you, not to the government through unnecessary taxes. If you do your estate planning properly, there should be no tax or no stamp duty when you have the assets moving to your loved ones. But if you do it poorly and it doesn't achieve the objectives, you end up paying heaps more tax and stamp duty. Or if there's a dispute, you end up just paying lawyers. So like a lot of litigation lawyers will say, oh, just go and get a post office will, because they know it's going to end up in a dispute and it won't achieve the right thing, and then they'll be there to get all the legal fees sorting out the dispute.
Because that's obviously where they make their money when it comes to
dispute. Exactly. Whereas if you just spend a little bit of time and get the right people to help you with the estate plan up front, it's just a smooth, streamlined process. It doesn't cost that much to get it done, particularly compared to, if you think about the legal bills for a disputed will can run in the hundreds of thousands. You just think, why not spend a little bit more than a post office will to get it done properly at the beginning, and then you don't have that money wasted. Another thing I just wanted to touch on, you said before about people who are in business with other people. So that's really important to think about what happens with your share of the business if you pass away, or your business partner's share of the business, because you may not want to be in business with your partner's spouse. You might, which is cool, but a lot of people, I think, wouldn't. So, particularly if it's like a manufacturing business, you may not want the wife suddenly being involved and having a seat at the table and disrupting the arrangements. And a lot of people work on handshakes and they've just got a good arrangement and they know how they've done business for years together. And that if you've got a spouse or even children, your business partner's children coming in, all of that goes out the window. So it can be easily avoided by having a proper shareholders agreement, and sometimes a document that we call an insurance funded buy-sell. Now, we don't have to go into the nitty-gritty of that, but basically it just means you have some insurance funding there so that you can easily buy out the estate of the partner who's died, so that you don't have to come up and scratch around to find this extra funding to buy them out, and you can just get on with running the business with as little impact as possible.
So that's a really interesting one about the partnerships, and it's something that I've seen happen, and obviously the conversation that we have with clients. And you talk to them and say, do you know what will happen do you know what will happen if you pass away to your partnership, to your business? And they said it'll just continue. And I was like, well, no, your wife or your husband is going to step in and they're going to be partners with your partner. And exactly the same. Do you want that? Do you get along with each other? Will the business still run smoothly? Chances are it won't. And a lot of people just don't think about that, because obviously, should be right, I'm not going to die. Everything's going to be okay. It's scary.
Exactly. And when you've got a business that really relies on the personal exertion of the partners, and it's all just sort of been handshake, and you get on fine as partners, and you have, or anything you resolve easily, it's easy to think, oh, I don't need to bother. But once you throw other people in the mix, it's a totally different dynamic, and the value of the business can be eroded so quickly once you have those issues. It's just an absolute distraction that no one needs.
On top of obviously the partner passing away. As you said, there's the emotional and there's the financial.
Exactly.
So if we try and bust some myths around estate planning,
Okay.
especially myths around young people and estate planning. We've maybe covered off a few of these, but the one excuse that I hear when I talk to especially friends and clients about getting their estate planning sorted is they say, I'm too young, it's only for old people. And we've touched on it already, but just bust that one for me.
Oh, look, everybody needs a will, really, once you turn 18. Now, your will at 18 might be super simple, but it's a good idea to have one. And for instance, like I take myself, I don't have children, so I go, oh, well, why would I need a will? But I have nieces and nephews and siblings, and I really want to make sure that my inheritance that I leave to my family goes, to my nieces and nephews in the appropriate structure. If my brother, touch wood, does end up going through a relationship breakdown, I don't want the money that I've left him for my nieces and nephews to be caught up in their divorce proceedings, and even, because again, once you're going through a divorce, it's the lawyers who are getting most of the money. So it's still important to have the certainty and peace of mind that the money that you've worked hard for goes to the right. And there's also charities that, if I'm not here, I'd like to support. So the government will that they give you doesn't deal with that. So it's a good idea just to get it written down. Everyone knows who's in charge, where the assets go. It's a pretty straightforward process. And, I probably won't have to touch it for years until I have children.
Maybe already touched on it, but I don't have any assets. Why would I bother?
Well, look, most people do. If you have a job, you have assets because you'll have a little bit of super. You might have more super, it depends. Yeah. But you'll have life insurance that goes with that. So you will have some, even if we're not talking cheap stations, you might as well have those assets go to your family and loved ones or charities than to the government through taxes. And what you really need is your powers of attorney sorted. So if you can't look after yourself, whether that's for a short amount of time or a longer ongoing period because you're in an accident or something like that, you need to have the right people charged with managing your financial affairs so that they can manage it so there's enough funding for you. And that's where insurance, I think, is really important for young people. So I don't sell insurance, that's your thing, but I think that goes hand in hand with having TPD and trauma insurance and income protection as well, so that if something does happen, you're not a burden on your family. And if your family is dealing with you having lost capacity because of illness or an accident, the last thing they want to do is spend time with lawyers trotting off to the Civil Appeals Tribunal, trying to get an order about who's able to make decisions for you, or dealing with the internal bureaucracy with the bank, the insurance companies, the hospital, proving that they're able to make decisions for you. Yeah. One piece of paper just takes all that white noise away to nominate who's going to sort things out for you. And I think it's really important not only doing it for your family, so they hassle sorting it out for you, but do it for yourself because you might recover. And if you've had people who you didn't want making your decisions and then you've got to live with those decisions, it may actually not be the right outcome for you. And then you're going, oh, well, you sold my apartment, or you put me through this treatment that I would never have chosen. So the power of attorney, I think, is really important for young people.
Definitely. It's always my recommendation. Regardless, if you don't want to take up a will, a power of attorney is absolutely non-negotiable. And that's probably one of the, adding on to that in terms of myths, speaking to parents that have 18-year-old plus children, so well, if something happened to your child, do you know that you're not legally able to take care of them? Or you need, as you said, you need to go to the civil tribunals and get appointed. And it's a shock to them because they think, well, I'm the parent. If my son's in hospital, I can take care of him. I can make those decisions. You say, well, no, you can't. He's over 18. He's not a dependent anymore.
And what if there's a spouse who is, may or may not be a de facto, or, they're not married yet, it's not clear who's entitled, and then they've got different ideas, it can just cause a huge amount of heartache when you've got competing people with different views.
That probably leads on to another really interesting topic that I have with a lot of young couples. So that de facto, that definition of de facto, that's probably, I'm not sure if it's your area of specialty, but that's a big one that I come across. When you talk to people that aren't married, they're living together, and potentially they look at buying a house together, that just rings alarm bells for me.
Oh, absolutely. Get it sorted. So the de facto, like once you've been living together for 2 years, but also if you have children together, then you de factos. And there's other criteria where you can be de factos earlier based on the sort of support and relationship nature. And that can get quite messy because under the intestacy rules, if you have a spouse, which includes de facto, then some of your assets go to them. And that may be good or that may not be good depending on, where you're at in your relationship. But also if, say, you do want it to go to your de facto and the family doesn't want that to happen, then your de facto is there trying to prove the relationship and having, if they've lost their partner and then the de facto's there trying to say, well, no, we are de factos, and having to do like statements about the intimate life. It's just a mess. Don't leave it up to everyone to fight over. If you did a will, it just becomes like a null point. Another thing I might just mention, even if you have got a spouse and, say your partner and you're married and you've got children and you don't have a will at all, what happens on intestacy? Not everything just goes to the spouse. The house does, and then like the first portion of assets, but the children actually receive like half of the balance of the estate. Or if you've got 2 children, they'll get like 2/3 of it.
So it's a set formula, isn't it? So
Yeah.
As you talked about, having the default, that X amount will go to your spouse and then X amount will go to each of your children, whether you like it or not.
Correct.
No choice.
So if you're the surviving spouse and all of a sudden your 2 children are sitting on a couple of $100,000 each, which you'll control until they turn 18 anyway, or 21, sorry. But then that money can only be used for them. And if you need that money to do other things, like pay off the mortgage or sit in your offset or invest, you don't have that option. Like, it's crazy when you've got like 5-year-olds sitting on like a couple of $100,000 because the will wasn't done properly. And then when they turn 21, it is their money. And you might have needed that money for there's no way you'd want to rely on the intestacy rules.
And I think the last kind of myth or probably the barrier for people getting a will is it costs too much. I can't afford it. What would you say about that?
There's different ways that you can fund the estate planning. So I would suggest working with your financial advisor, someone like you, Russ, because there's options out there for the financial advisors to get it sorted for you in a manner that's pretty good value. They can also help you if part of it can be funded through superannuation. They can help with letting you know about that aspect of it, and not all of it can, but some of it can sometimes. So that helps because it's not, you're paying for it, but it's out of your super, so it doesn't feel quite out of your pocket. But it's like insurance. The cost of getting your estate planning sorted now is just so much cheaper than if you don't get it done and something goes wrong, which usually it will go wrong if you haven't got a proper estate plan. So spend a little bit of money now to save hundreds and thousands if you need it.
Definitely. Good advice. So where can people get in touch with you?
Oh, well, I have quite a lot of the social media going. So I'm on LinkedIn under Tara Lucke, that's Lucke. I'm on Facebook under Tara Lucke Legal. I'm on Instagram at Tara Lucke Legal. And I'm also on Twitter at Tara Lucke Legal.
So if you want some legal tips, I recommend that you follow Tara on Instagram. There's some great videos on there. Well, thanks very much for being on the podcast.
My pleasure. Thanks, Ross.
If you've enjoyed this episode of More Than Money, make sure that you subscribe to keep up to date with all of the latest episodes. And feel free to like, comment, and share with a friend.